evictions. Don't pay the rent. If at home we have to stay, then most of us can't pay, so don't pay the rent. Tell your landlord, sir, that mortgage can defer, and don't pay the rent. If they start rattling their sabers, say I need to feed my neighbors, and don't pay the rent. It's time now to demand one big union grand. Don't pay the rent. Neoliberalism is dead. It's time to raise your head and don't pay the rent. Strike for the guarantee, a home for everybody. Don't pay the rent. Running water, housing, healthcare all across the earth we share, yeah. Don't pay the rent. Capitalism has failed. Put the billionaires in jail. Don't pay the rent. We need a new world now. Let me tell you how. And don't pay the rent. With mutual aid, a new world can be made. Don't pay the rent. From the ashes of the old, if we stop doing what we're told, and don't pay the rent. Solidarity with society. Don't pay the rent. Our lives matter a lot. The landlord's profits do not. Don't pay the rent. We can redefine what is theirs and ours and mine if we don't pay the rent. There's a suspension on evictions. Stick to your convictions. Don't pay the rent.
Second verse. Okay. All right. Hi, everyone.
Hello.
Glasser accused me of shtick in wearing this, but I got 2 college kids coming home. I need to stay safe somehow. So, Lauren, give us the heads up. Do we get Marvin on the call?
Oh yeah, I was here. I heard the song.
All right. All right.
Are you singing, Ron?
I was singing. I was rapping.
That's very nice.
So I guess we're letting everyone come in still here. We'll give it another minute. We're going to start. It's 3:35. All right, guys. So my name is Ron Abrams. I am a housing provider. I'm also an attorney, but we'll keep that on the down low. I'm proud of the industry. I have somewhat of a script, but I'm first and foremost, it just hits me that as an industry, we've really done well. We've shown a lot of empathy to everybody. I believe we've done the right thing. I've seen 99.9, I don't even know anybody who hasn't done the right thing. All I know is that the tenants who've come to me and come to my peers and my friends that need help, we've given it. And in the meantime, government probably, there's been a lot of wrong stuff, wrong place, wrong time stuff going on. But, that's just kind of my little personal pitch right now, that I am proud of the industry and I'm proud of MBOA. NBOA has been representing you and trying to do the best they can. We've hired professionals to help us and keep us on track. And we'll talk a little bit more about NBOA, but I think things could have gotten a lot worse if we weren't around. So thanks to Mike Glasser and the NBOA crew. So just a couple household cleanup things. Our moratorium, we're going to hear that word a lot. That's a legal term, and it derives from the term to delay, obviously. But today, it also means to drink. So every time you hear the word moratorium, thanks Sam Goldman, feel free to take a sip. Now, of course, I'm kidding, because eviction moratorium is not something to be joking around about. And in all seriousness, this is very serious for a lot of people. Today's program also had the highest rate of email openings, which I found really interesting. This means to like a non-techie like me, you guys are actually interested in this topic, or you wanted to find out why the picture of me looked like this guy had a giant head. So one of those two things. Okay, the rules. Lauren just put up on the screen that you may want to hit the speaker view so you can see who's speaking. You can go to gallery. It's America. You can choose what you want to do. Please mute yourself. I wanted to remind you that this Zoom is open to all, including possibly housing advocates and the media. But hey, we're going to get to the intros, but first, have you heard the one about the lawyer who died and went to heaven? That wasn't the joke that they went to heaven, but okay, let's start again. So the lawyer who dies and goes to heaven, the lawyer says, I'm too young to die, I'm only 50. And the gatekeeper at heaven says, you're 50? And he goes, no, according to our calculations, you're like 85. And the lawyer asks, how'd you get that number? And the gatekeeper at heaven said, oh, we just added up your timesheets. So with that, we have 4 lawyers today presenting to you. So, they are lawyers, we are lawyers. I direct you to LinkedIn to get everyone's full scoop. I'm not going to read all about these fine jurists who gave up big corporate jobs and millions of dollars a year to serve us, the housing providers. Remember, the Zoom is for informational purposes only, and the information provided is not intended to constitute legal advice. So the legal team you're going to hear from today is Michael, I don't stink Zink. He's up there. Say hi, Mike. Okay, you can see what he looks like.
How are you?
Yeah, he is not wearing pants, but he told me that in confidence. I was just thinking that. I didn't mean to say that. We got marvelous Marvin Hoosby, a 5'2", 250-pound power forward. Where's Marvin?
Hello, Ron.
Hey, what's up? He's really 5'3". And then we have the big E, which I've now learned is a super tall woman, the big E, Ebony Lucas, at 4'11", but lying and saying she's 5 feet tall. So Ebony, wave so we know who you are. Say hi, then you'll show up.
Hello.
All right. So hey, let's get right to this. As you know, Governor Pritzker enacted an eviction moratorium in March. He's extended it 8 times so far. And the most recent executive order is Executive Order 2020-72. Ebony, can you start us off and kind of tell us where we are today?
Yes, good afternoon, everyone. I'm Ebony Lucas, and as Ron mentioned, I'm a real estate attorney and I represent housing providers in matters like this. I'm going to talk a little bit about the governor's newest moratorium because it made some changes that allows some evictions at least through December 13th. First of all, there's no limit, apparent limit to evictions over $99,000 if the tenant makes $99,000 or more, or has a combined income of $198,000. If they make less than $99,000, well, let me back up. One of the things that this moratorium did was to say tenant or resident of the property. So we've heard a lot of people talk about issues with squatters or people that don't have a lease or people who move in and, the person who was on the lease moved out, those type of issues. And now they're actually saying any resident of a property, period. So it sort of expands the definition of tenant to anyone who's living in the property. If they make less than $99,000 or a combined income of less than $198,000, then they have to provide an affidavit to the housing provider that says that they have a, either they have a COVID-19 related reduction in income, or they have an increase in expenses for food, utilities, phone and internet access, school supplies, cold weather clothing, medical expenses, childcare, and transportation costs, including car payments and insurance. So if any of those things went up, they can provide an affidavit saying that they're having a hardship due to this increase in expenses or a reduction in income. And that affidavit also has to state that they are making efforts to pay. So if they're not making any efforts to partially pay, then they're not covered then under the new order. So the new order defines covered persons, and it also requires this affidavit from the tenant. With respect to prior evictions that were already pending, the order says that the sheriff can only move forward on those for health and safety reasons. So we're sort of in the same place that we were with respect to evictions that were filed previously. The issue with yes, someone asked about a written summary, and absolutely, I'm happy to provide a written summary that Lauren can probably email out to all of the attendees. If they don't provide the affidavit, then they're not covered then under the ordinance, and you can move forward with your eviction. The problem is the ordinance does not say when exactly they have to provide the affidavit, which is a bit problematic because you could file your eviction and then they could provide it after the fact. And there's nothing that would prohibit them to do that. So I think Marvin Hoosby is going to talk a little bit more about service and how to serve people and timing on service. I don't want to run over my time. I see Ron.
All right, you're done then, Amity. No, I'm kidding. But no, hey, look, I'm hearing all these things about the eviction order. The question to me, and I think the people out there that are watching right now is what's changed? Is the door open at all, or is this just more ways to tell you you can't evict? And once again, I want to remind everyone, we're not trying to evict people. I mean, we want to take care of the people who are gaming the system, and we want to play on a fair level, and we want to move forward from the people who stopped paying us before COVID. So, we're not looking for ways to evict people. I think everyone on this call will agree that that's the last thing we want to do is in November, December, evict people and have empty apartments and provide hardship to people. So I don't know, too much for me, but Zink, what's different? Is there anything different?
So I want to say one more thing, Ron, really quickly before we skip to that. And that is, don't forget about the Chicago ordinance, because the Chicago ordinance sort of steps in after the state ordinance, and you still have to try to send a notice to the tenant, ask them if they have a COVID related issue, and try to set up a payment plan or try to get some type of agreement for them to move out. So you still have that obligation.
We're going to go back to the Chicago ordinance for sure, because it's
right.
very confusing. All this is very confusing. I'm interrupting because I'm trying to break it down really for easy reader, because I see some of the faces out there and I know they don't get it. So Zink, what is different? Is there something different? Is there a shot for us to get on fair footing, or is this just more lip service from the governor? You're muted, Mike. Uh-oh. Did he send a bill and we didn't pay? All right. Hey, Hoosby, you want to pick up on this one?
I'll jump in.
Okay.
So prior to last Friday, so prior to 7 days ago, we could only file new evictions that threaten the health and safety of other residents, or were code violations. What this changed is it allows us now to file any non-payment evictions as long as the tenant does not return the declaration, and I'm going to share with everyone what the declaration looks like in a minute. as long as they do not return the declaration to us prior to filing, we're allowed to now file that eviction and proceed.
All right, hold on, Marvin. Declaration. Give it to break down. If they don't file a declaration, when do they have to file it? When do they get notice? Who's giving them notice? Trump giving them notice? Who's doing it?
So Trump is signing the declarations for everyone, just like the checks. Now, if we could turn off, if we could do share screen, there we go. Somebody shared it. This is what the declaration looks like. And so I'll get to in a minute when you have to give them this declaration. But if this declaration is not returned to you within the 5-day period of a 5-day notice, then you can now file your eviction. And why that's important is, you know, there's all
Are you
these
giving them,
studies that are,
Marvin, are you giving them this declaration?
yes, we are.
Okay.
So what Pritzker's modified moratorium states is that we have to give the tenant a copy of this declaration prior to the issuance of a notice of termination of tenancy. So the big thing becomes what is prior to the notice of termination of tenancy mean? And it gives us several options, right? And we won't know till judges interpret it. One option is we all go home today, we email this declaration to all of our tenants. Now they've all received it. Now 6 months later, we go to evict somebody, and we're in court, and the tenant says, "Judge, I never got that declaration." And I sit there and I say, "Well, Judge, yeah, 6 months ago we emailed it to him." A judge is not going to like that. It's not within the spirit of the law. One judge might agree and say, "Hey, it doesn't say when you got to give it to him." And one judge might say, "You know, the spirit of the law is that you give it to them before you serve them the notice," meaning right before you serve them the notice. So I don't think that's a good option, and I think it would spark all kinds of things being returned to you that are unnecessary.
So what would you do, Marvin? What is Marvin Hughes
I would do
tell us
one
to
of
do?
two things. So if you have the capacity to make sure your management company, or if you're a smaller landlord, you have the capacity to say, "I'm going to send this notice, and now a couple days later, I'm going to serve a 5-day notice," I think that would be fantastic. I think all the attorneys on here, because we've discussed it, we all tend to agree that if you don't have the capacity to do that, and you just attach this to the front of the 5-day notice, that most of the judges, we believe, will consider that prior notice, because the spirit of the law is really that they get this notice and they have an opportunity to fill it out and give it back to you. That's the spirit of the law.
Hey, Marvin, would you put in your affidavit that you served it? Or would you have a separate document, a separate affidavit from the housing provider that you did give them this declaration?
So you could do that. Your testimony should be sufficient. You could write a note on your 5-day notice, or you could copy it to the back of your 5-day notice. So, and copying it to the back of the 5-day notice is something that I think is great. But really, it's that you gave it to them. And then when you testify, you'll testify that you gave it to them. And I think that'll be sufficient. You know, one thing
is Zink, one question, is Zink back?
I am.
Hey, Mike, why don't you jump in here for a second? And, you know, is this the wrinkle, this new declaration? Is this what's going to really get the ball rolling, or is this just another piece of paper? And what are the judges going to do with this?
Depends on you ask. Well, it's definitely not just another
I'm
piece
asking you.
Definitely not just another piece of paper as far as the judges are concerned, because they're going to be looking for it and when it was given. The FAQs that were also on the website for IDA says specifically that the tenant can turn in this declaration at any time. So as a few people have already talked about the last week, what does that mean? Does that mean they can do it, you know, after you've already filed a case? Suddenly they just walk into court with it? Theoretically, yes, that's exactly what the language says, and that's what their FAQs even say. What is the judge going to do with that? Are they just going to hold the case into abeyance and continue it, or are they going to dismiss it? Again, nobody knows for sure, but the rules under IDA and the FAQs seem to say you can give this at any time. The tenant can give this at any time to the provider. Another point about this too, I think Marv is about to go into is what if this is false? What if the provider can prove that any of these statements are absolutely false? Well, again, nobody knows for sure, but probably you go ahead and you file your case and you know, with your proof ready to go, so that when the judge is confronted with this provided declaration, then you provide the judge with the proof as to what was done properly and what essentially this would constitute a subordination of perjury, and then the judge would probably disregard the document.
I was going to ask a different question, but you just said perjury, which isn't moratorium. I thought you were going to say, okay. But when you say perjury, I mean, if these people are signing this and making more than 100 grand, or that they haven't paid you one dime since March, and you know, there's a clause in here that says that they're using their best efforts to pay, or
Partially.
what do you, I mean, I'll open this up to the panel. What do you think is going to happen? I mean, you guys are in court every day. Do you think a judge is actually going to find someone and you know, and say they've been perjured, or is anyone going to go after these people, or is this just kind of, it's just not going to happen?
It's not likely that
what'll happen is that.
Oh, go ahead, Ebony.
No, I was going to say, I think what'll happen is that then the judge will just enter the order for possession. I mean, they're not going to, like, you know, fine the tenant or, you know, criminally charge them with anything. I think it's just that, you know, that if you can show that that any part of the affidavit wasn't accurate, then you can move forward with your eviction, and the judge will enter the order for possession.
So is your, you know, I've asked this question a couple of times and you guys are acting like lawyers and not answering it. Do you think that this is a game changer? Is this going to help us, or is this just more paperwork that as housing provider, we're going to screw up the way we do it?
Absolute game changer, Ron.
Okay.
Absolute game changer. And how the NBOA got this thing entered, I'll never know. I mean, here we got the numbers skyrocketing. We got
good
Thanksgiving.
Lobbying, good lobbying.
What?
Good lobbying.
It must be, because at the time, I by the way, if we were acting like lawyers, Ron, we'd be lying. But what happened here?
You know, I don't know if I have an obligation to report that, Himmel obligation. Sam Goldman is taking notes. I see it.
Yes, but one of the truly shocking things about NBOA getting this in is we have rising numbers. We have Thanksgiving followed by Christmas, followed by winter. If I were a betting man, and thank God I'm not, I did not expect any changes till March. So when I say it's a game changer, it's not a game changer that we're back to normal. It's a game changer that nobody does, tenants don't do anything until it's on the line. You know, there are all these studies about unemployment, and people don't look for a job until 4 weeks before their unemployment runs out, right? And all those things. When you get to court, tenants will now be in court, and tenants will be in front of a judge who wants this resolved, who for the first time in a long time actually feels bad for landlords, who sees a large balance due, who will push the parties towards settlement, whether that be a payment plan to start, or whether it is a move out date and tenants voluntarily move. Now, of course, the killer here is the sheriff still won't go out on non-payment and remove them. Not everybody knows that. Not everybody knows how it works, but the judges will be leaning on the parties to resolve this. And to get back and add to what Ebony was saying, what will the judge do if these are false? These affidavits are false? They will do what the judges always do, which is they will look at the tenant and say, you signed this affidavit under oath. I'm going to send you in a chat room with Mr. Hoosby. And I want you to know that, are you sure you could not have made any payment to the landlord in the last year? Because that's what you swore under oath to me you couldn't. And then he'll send us in the chat.
Wow,
I
think
really
someone's posturing to be a judge.
I know, and that's
Judge
how it works.
Tuesday.
The judges are going to push parties to come to an agreement that hurts both parties. Landlords, don't walk in there like it's going to be we're easy and free. this is great because it's going to force the parties to come to an agreement that may, be painful for both.
I love that that this is something positive. There's not a lot of positives all the time. The flip side, Ebony or Mike, you guys are in the courtroom. We've heard that they're limiting how many cases they hear. I mean, this might be all great and dandy, but if we're number 300 on a list and they're only doing 10 a day, I don't know what's the pipeline look like, guys.
Well, I have to tell you, I mean, from what I've seen, a couple months ago, you'd file a case and you get a court date in February and you had to file a motion to get it in sooner. And now you're filing and they're actually giving court dates in 3 weeks. So
Wow.
that's something that I have seen.
And I'm not sure how strictly they've been following that 10 cases a day order that came out months ago. Frankly, I don't think that even exists. I don't think they're even thinking about that anymore. They're just putting these things out there. Even the computer system, for a while it was kicking cases automatically into early 2021. Now we just found out that basically the computer is not going to automatically generate dates anymore. So things are constantly fluid. So back to Marv's point too about this being a potential game changer too. One of the other kind of behind the scenes way it might be a game changer is working with Judge Evans, because in Cook County, as Marv and Ebony mentioned earlier, we have multiple layers of having to deal with these evictions. And the governor's moratorium is just one of them. One of the other ones, and one of the most important ones, at least for Cook County, is Judge Evans's order. Judge Evans has had his own moratorium in place for months, and he's modified it from time to time. But the reason that it may be a game changer with respect to Judge Evans is because Judge Evans's order is supposed to follow the governor's, at least in spirit. It is the way it's worded. We still have yet to hear, unless something happened today that I didn't hear about. I don't think that Judge Evans has changed anything yet on his order. But if he sees that the governor is now opening things up just a little bit, it might be that Judge Evans perhaps takes a cue from that.
Well, let me ask you this. So, okay, we've talked about Judge Evans' order. We've talked about serving the tenants and using the declaration to, I hate to use the word to our advantage, but to use it as it's intended. And I don't know if we've talked about the sheriff a whole lot. Ebony, can you maybe talk about the sheriff? I mean, is the sheriff serving these things? Are they going out, or is there a giant sheriff backlog? Like, I want to talk about the practicalities of all this and what it means to us. I got some follow-ups, obviously, but go ahead.
So in my experience, they are serving summons to cases. So when we file them, when we're going to court, the sheriff is serving the summons.
So is there any backlog at all, you think? I'm sorry,
you have a court date within 3 weeks. So, I mean, you're going to court and there's service there. So I don't know that there's a backlog in actually serving the notices. On the eviction side, like they said, the sheriff is not doing any evictions except for the health and safety evictions. So, once you get the order, I guess it places you in line with the other evictions that were filed in 2019 and are still waiting to be evicted. So it places you in line, but the sheriff is not gonna go out and evict on these cases if they're not helping.
I spoke to Lieutenant Ponron in anticipation of that question, and he says they're not backlogged at all. And what I would say is that my commercial evictions, which the sheriff is going out and executing, and my health and safety evictions that they've gone out to executing, it's only taken 2 weeks. So I don't think there's a serious backlog. I think there will be once all this stuff goes through, but as of now,
that's all very, very positive. I want to take a quick time out to acknowledge that the Chicago Apartment Association and the Illinois Realtors work close with us to influence this governor's emergency order. Once again, the things NBOA has done has not, we didn't stop an eviction moratorium and we didn't stop the publicities on, a rent holiday. And, there's some negative connotations about being a landlord. But at the end of the day, we're chipping away at it and making, I think, everyone feel a little better. And there's actually some articles and some case studies that show that, landlords are getting hurt. I mean, look, at the end of the day, this is my business. Like, Nobody's going to a banker and saying a banker should make less money or a fireman should make less money. They're only coming, they're coming to the housing providers and saying, that we should make less money. And, every day we have a lot of risk. I mean, I'm not telling you anything you don't know. We have a lot of risk. In 2007, I lost almost everything I had and started rebuilding from there because I took a risk and signed on a giant mortgage to build a building, and there's supposed to be risk and reward in this business. So, I think the NBOA has really done a good job of representing us. They were in crisis management mode when we started. They've been fighting legislation. We've been doing PR. We've dealt with just cause and fair notice. There's the new ARO. There's the RLTO. There's the RTLO. And these are all other broadcasts that we'll do later, or webinars or Zooms, or you've been at them. At the end of the day, we got op-eds in the Chicago Tribune. We had something with WBEZ. I mean, we're working our ass off. And, we should thank Mike Glasser. The amount of time that he's put in is scary. The flip side of all this is we're going to make an ask. And you'll be getting some phone calls. We're looking for some help monetarily to keep this going. We have paid professionals on the PR side and the lobbying side. And, everyone on the board, me, Mike, our speakers, we're all volunteers and we're spending a lot of time on it. So if you're not spending a lot of time, or you're appreciative of the things we've done with our time, we're going to ask you to contribute to the cause. That's about as strong as I'm going to get. We will follow this up with a donate button at some point. Remember, we got problems with ceilings of evictions, just cause, relocation fees are coming. I mean, there's a lot of fight here still, and all this stuff is at the wrong time. I think at the very least, we got to show them that this is the wrong time. All right, that's my public service announcement. They said it would be too boring in the beginning and we lose people at the end. So that's Glasser's idea. And let's go back to evictions. We left off saying that this was like, I think we left off feeling kind of good. Like, this isn't people aren't going to be able to live there rent-free for a year. I mean, guys, can you elaborate a little bit? I mean, do you feel like this is not going to be as bad as we thought? I mean, certainly we don't love people staying in our apartments that are squatters for a year and not paying rent, but I think we all thought this was going to be worse. No? Ebony, Mike?
I think this is, it's still a pretty dire situation because right now, by and large, you can only go forward on cases where there's a health or safety situation. And so it leads to this kind of almost a perverse hope that the tenant does something so egregious that you have grounds to go after them and take them and to get them out. And otherwise, if the tenant's behaving themselves, there still isn't a whole lot of recourse there, especially with Judge Evans's order in place still. So it's certainly, like I said, I think Judge Evans, the governor's order, I think is more of a incremental step toward, making a recognition that there is something the housing providers, they need some relief here.
Well, Mike, you just mentioned the emergency motions. What is happening with those, and what rises to the level of emergency? And, quite frankly, I'd like to think that the housing providers are doing the right thing, but do you see any abuse on our end?
Not really. Providers have been, it's one of those things, when you see it. Nobody knows the answer, but you definitely know it when you see it. And I think both Ebony and Marv have both filed a bunch as well. And we've done some in our office. And they're pretty serious situation, drug dealing.
Like what? I mean, we can talk about it.
Yeah, so let me give you some examples. So
Yeah.
Drug dealing, you have somebody basically committing batteries against other people in the building, causing different property damage throughout the building. I had one a few weeks ago with a gang member that was threatening a family in a building. Those kind of things, what you need testimony, and you need documents, and you need photographs as necessary. But basically, the more incidents you have and the more details you have behind each incident, the more that the judge is going to see it as a pattern of behavior as opposed to some one-time thing that may or may not be a threat.
Well, I changed hats because Ebony didn't even flinch when I put the Ohio State hat on. I mean, she's University of Michigan. I mean, she's a little shell-shocked. They haven't won in like 9 years a game. But what's your tale from the front lines of emergencies? What rises to an emergency with you?
So I think it's like Mike said. I mean, it's really been, you know, a situation where there are police reports, there's some type of violence or some type of threat of violence. It has to be a very serious situation in order for the court to evict, based on the health and safety provision. You know, I have one now where the tenant actually moved out, but just refuses to give the keys. But my client is concerned because the utilities aren't on in the building. And I was a little concerned about whether or not the judge was going to go for that, but she is. She said that, you know, she did find that that's a health and safety issue because it's a possibility that the pipes could freeze and bust. And so she gave an order for possession in that case. But I think that that was a little bit different because the tenant actually just moved out and is just sort of being a jerk and not giving the keys.
That's almost like a reverse lockout situation. Today in USA Today, not that I read USA Today, but it popped up on my phone, was a pretty in-depth article about, you know, housing provider, landlord abuses in, you know, self-help and lockout situations. And once again, I mean, you know, that's one of the things the housing advocates are hanging their hat on. They're saying that we're using these horrible tactics and they need more protection, like in the RLTO or the RTLO. And, you know, we got to stay strong and we got to make sure we don't slip up and do any of this stuff. Once again, panel, do you see any, you know, and be honest, I mean, have you seen in courts anybody using self-help or lockouts? Have you seen this in the courthouse?
I have seen Ron, I haven't seen any motions filed for constructive eviction, which is commonly referred to as lockouts, which we would see if it was happening because there were so many pending COVID cases. So I think landlords are well schooled in what's going on in terms of what they can't do. I think where landlords need a little bit of help is with what they can do. And talking about these emergency motions and what we're talking about today. And just to piggyback what Ebony said, you know, somebody being, the apartment being vacant, and the judge granting that order, it's good work by Ebony. And at the same time, I believe the judges are trying to help landlords. I believe they understand the issues. I've had to go a step farther. We've had a couple where I wasn't sure if I was going to get them or not, and I got them, where there was a leak in an apartment and the guy 3 times refused to let us in to fix the leak, and it's leaking in the tenant below. But what's the key to that eviction? Why did we get it? We got it because the tenant below appeared on Zoom and said, "This is ridiculous. I got this flood in my apartment." You know what I mean? So, so judges are.
Did you wear a hat and big glasses and a fake mustache when you testified, Marvin? Or
I the glasses in the nose I do, but not the mustache.
Okay, I thought so.
So one of the things I think that somebody asked in the chat was whether or not you have to give that declaration if you're trying to evict for some reason other than failure to pay rent. My recommendation is, I think judges are, and in general, they're looking to make sure that the file is complete. So I don't think it hurts to just give that affidavit anyway, because you would hate to get to court on a situation where you're trying to evict someone and they come with this whole sob story about how they had some type of COVID related issue. And, you know, you're trying to evict them because their music is too loud or something, or they're disturbing other tenants or something, having nothing to do with money, but they have the sob story and you didn't do the affidavit. I think that it's probably best to have the affidavit, to attach a copy of your lease, to attach an affidavit from yourself saying that you attempted to try to work with the tenant, really to have, and saying that you gave them that declaration. I think to have a full packet when you file the eviction is very helpful. And I think it really helps your case.
I strongly agree with that, and especially because of the general wording of this new moratorium regarding this declaration. It specifically says, you know, it talks about tenants and landlords.
Wait, moratorium?
Right, but it also says, oh yeah, absolutely. But it also says resident. So in other words, it talks about tenants, but it also says resident. Well, what does that mean? It means somebody who's there without a lease or a tenancy. It means somebody who just happens to be residing in that property, which potentially means squatters. So I think just the general wording of that, although it's not well defined and certainly isn't addressed in the FAQs, as an abundance of caution, you really do need to give the declaration before you give any notice.
So I'm gonna do a little bookkeeping here. I'm getting inundated with questions, and guys, maybe if you can help me look into the chat as well. But I want to make sure, we're answering some questions. I mean, we have a bunch of comments here that, people are very concerned about squatters and tenants that are doing the wrong thing and our inability to rectify that situation. I'm getting texted about the old CRLTO and the RLTO. People who didn't pay for 6 months and they're destroying the apartment, and
If they're destroying the apartment,
So
there's
in
no
a-
reason to wait.
Right.
You can get an
Right,
emergency
and in that situation, I wouldn't even, what I'm telling my clients is, if it's a situation where they're destroying the apartment, the judges do see that as a health and safety issue. And the health and safety will help you get the sheriff out as well. So if it's a situation where they're not paying money, you may have to just not worry about the money and worry about just getting them out and file for the health and safety.
Look, I see a lot of frustration here. I mean, if tenants don't have to pay, why should we have to pay taxes for institutions and schools? I mean, there's some questions about, I don't know. I'm just paging through. I'm sorry, I'm not being perfect on this, but
And
go ahead,
Ron,
Mark.
I would just say we should have Joe Moore comment here if he's available. But
Wait, we only have 15 minutes left. I don't know if we have enough time.
okay, but those frustrations are legitimate and they need to be addressed to your state reps. They really do.
Mhm.
I mean, here's concern for the cold weather. I mean, I think everyone in here knows, I mean, the cold weather rules. Do you think that it's going to change at all this year? I mean, I guess the ultimate question is, maybe each of you guys can take a minute right now and just kind of tell me where you think this is all heading. I know it's conjecture and, who knows with COVID, but where's this whole thing headed? And when do you think that there actually will be evictions carried out? Why don't you start, Ebony? You're on my screen to the left, and then Marvin, then Zink.
Well, we had a very good call, we meaning MBOA, because as you mentioned, MBOA has been doing an awesome job advocating for housing providers. And we had a very good call with the governor's office this past week. And one of the things, and I'm going to answer one of the questions on there and your question that they talked about, is that they've really been fighting at the national level to get more funding for housing providers. So someone asked if there's more money coming down for housing providers. And we're really hoping so. And they're saying that they're really fighting for it. So hopefully we'll see some more of that. Because from what I got from that call and everything that's going on is that it sounds like it's going to be, spring to summer when, it'll open back up, and we don't know if it's going to open and it's just going to be gradually and you can do some, or they're going to say, okay, well, if this person was, delinquent for XYZ amount of time, like we don't know how that process is going to roll out. And they don't know, they're still working on that right now. But, we really are continuing to advocate on behalf of housing providers. We've talked to aldermen. We had a round where we were talking to aldermen individually. We've now talked to the governor. We've talked to the sheriff's department, really trying to talk to them about what the issues are with housing providers and about what we believe the solutions are, and really inviting them and asking them to come to us and talk to us as they're putting things in place. So I think that they're starting to give us relief because we're speaking up on behalf of ourselves. And for a while, I think they were only hearing one side of it, and that was the tenant side. And now they're seeing us, all the people on the phone right now, the small housing providers that, are providing jobs in our community. We're providing housing in our communities and really working hard. So you changed hats. So I guess that's my time to stop talking.
Oh, that would have been good. Like, that would have been
I
a
got
good
the
system.
hint.
I won't talk about the system we used in the fraternity, handing out roses and stuff. We won't talk about that, but that was a long time ago. Statute of limitations over. Marvin, where do you see this thing's going?
I think we're gonna be with this moratorium until March. I noticed in the chat question, someone said, do you think the collar counties will be different than Cook County? I think once they free up evictions to happen by the sheriffs, I think unfortunately, you may even end up with a situation where the collar counties are as backed up as Cook counties because they're not as used to the volume. And I expect the volume to be bigger. So
When's the sheriff going to come? When is the sheriff going to come out and start handling the evictions?
not before March,
Okay.
Yeah.
if I had to predict.
Zane?
Yeah, I would echo that. I mean, I think it's for straight money, for straight non-payment of rent situations. I don't think the sheriff's going to be doing any evictions till spring. So I think still every provider has to be on the outlook for any misconduct among tenants. That's probably going to be the only way to get anybody to move or to have to go to eviction court on them if they are committing misconduct. It's one of those things like Marv and Ebony were talking about earlier. The judges are human too. They see these things. They know that in the vast majority of cases, and I personally haven't seen any case that a judge has refused on the basis of a provider not providing enough grounds or that it otherwise wasn't a health or safety issue, because every case that's been brought that I've seen and that I've brought myself are very serious situations. They're not some end around trying to get anybody out. As we talked about earlier, eviction is the last place that anybody wants to be, both the provider and the tenant. And nowadays, especially, the eviction needs to go forward for any tenants who are committing this misconduct.
Okay. Well, we've gotten a lot of questions about assistance. And once again, another feather in NBOA's cap. We had the director of the Illinois Housing Development Authority, IDA, come to us and ask us what we thought of the program, how it was administered, and we're talking about the $5,000 grants, how it went down, and they feel like they're going to have more money, and there's going to be a second round, and they want us to help them streamline the process. I mean, that alone. I mean, I'm not a giant housing provider, but we got 12 grants for tenants, and the tenants were very, had a lot of gratitude. And look, 12 times 5,000 is a lot of money. I mean, it's not just one building, but it's really meaningful and it really helps the housing provider. So super, super successful reach out by Glasser and Alderman Moore and our team. Kristen Faust is going to be on one of our next webinars. So be ready for it. And it's a direct pipeline to telling IDA what they did right or wrong and how we can get more money. So another, I feel like we're doing too many shout outs here, but, and trust me, I wasn't a guy in the beginning who thought this kind of lobbying or this kind of PR was exactly the right way to go. I felt that, housing providers were always going to be a villain and there wasn't a whole lot we could do about it. And I think I've been proven wrong. I don't want to just talk to talk. I think at the end of the day, I'd like to really kind of, end this maybe a little early. I really would love for the panelists to take a minute or two and kind of really streamline what the process looks like. And I'm going to add one more question. It's almost politically a little incorrect, but do you need a lawyer to do this? I mean, are you getting better results if you have a lawyer? I know there's a lot of small housing providers that just don't want to pay, which is totally understandable. You're lawyers. I did that with a straight face, you see, I'm good. Can they do this themselves? Are the results going to be the same, or there's so many nuances? You're crazy to do this yourself. Question one, and then question two, can you guys give me like a summary, exactly how to do this right? Maybe easy reader kind of stuff. Marvin, I'm going to give it to you because I don't want you to have the last word because we'll be here till 5. So why don't you go first?
Perfect. I think you should have counsel. I know the other two. I know Ebony and Michael, and in our office, it's not outrageously priced, and I really do think you get the value out of it. Because if you're missing anything here, guys, you're in big trouble, and it's not going to happen, and you're going to end up spending more money redoing it than you would have. If my buildings, the the declaration would go out on the 1st of the month if they fell behind, and I would serve the 5-day notice on the 5th. That's how I would do it. And Ron, this is for you. I've been waiting.
Nice. Nice. Are you drinking tequila too?
Yeah, that's right.
Is that improper?
I think that's okay.
Okay, good, good. I'm wearing a chance hat. I mean,
That's right.
all right. You know what, Ebony, what's your feeling about a professional, and, what do you think the most important takeaway is here today? And I'm kind of guessing it has to do with the declaration, but you
Well,
don't
I
need
think the most important takeaway from today is your first question, which is you should use a professional. I think that which we didn't get into too far, but between the governor's order, the judge's order, the Chicago ordinance, there's a lot of documentation and just nuances. I was on a call the other day, on the court call, and there was a gentleman who was trying to represent himself, and the judge was telling him, you need an affidavit, and you need this, and she was listing the things. And, I'm sure that he's still not going to have it the next time. And she said, look, we're going to go to trial on this day, but I need you to make sure you have these things. Otherwise, I can't move forward. I think that there are too many requirements right now. And unless you have thoroughly read the law and you have a thorough understanding of the law, and I think that, especially with the professionals that are on the phone today, we all know the judges, we have relationships because we're before them all the time. I think kind of knowing what judges you can say what and give what to and how to work with them is important right now if you're really trying to get someone, if you really need to remove someone from your property.
All right, before I go to Michael, I want to know how you're supposed to bill an attorney that asks a question. Dan Pekarski asked a question. I thought it was a great question. I don't think it's today's topic. We may make Dan come on a Zoom, but he said, how are the property owners showing their loss of income in their P&Ls? It matters for real estate tax appeals to show actual and potential losses for 2020. Sounds like a Zoom for property tax appeals and maybe a CPA or an accountant to come on. So Dan, thanks for volunteering. All right.
I know Dan Pekarski, and he knows his stuff very well. So I'll volunteer you too, Dan.
So Mike, what's your big takeaway here, and maybe your eviction 101 tip today?
Well, definitely get a lawyer, because in addition to all the paperwork we've discussed today, there are other ones both locally in Cook County as well as a Supreme Court affidavit now that are all required as well. There is simply no tenant and no provider statewide who should be doing anything without a lawyer at this point. And as you mentioned earlier, Ron, there's going to be a new ordinance countywide that's going to create even more issues that are going to require attorneys.
Maybe, hopefully not.
So yeah, we'll see. But by and large, though, things are improving for the provider as well. I think this governor's moratorium from last week is one step in that direction. As I said, in Cook County, there are still a few hindrances specifically, but statewide, it certainly opens things up a bit. And I think that it's going to be around for a little while longer. But you also look for the governor to continue to reach out to both the providers and the tenants, because I think there seems to be some kind of an effort to reach an equilibrium, to understand that to one extent or another, the parties are in the same boat. And just because the tenants are suffering doesn't mean that the providers are not suffering as well. And especially because the small and mid-sized providers are disproportionately hit when these kind of situations arise.
Well, thanks everyone for participating. Thanks to our panel. I'm trying to stay positive here, and I think a lot of people are staying positive. And I read a great article about the Spanish flu and the Roaring 20s that followed. And I don't know, if anything, I just toast to the new Roaring 20s. Hopefully they come back soon, and we'll meet under better circumstances. And let's right the ship. I think all of us are pleasantly surprised to where we are today. I am, and it's a lot more work for less money. But thanks to the guys in the Zoom and the NBOA, I think we have a lot of direction and a lot of help. So thanks everyone.
Thank
you got right.
Thanks for inviting us, Rob.
You're welcome.
Thank you.
Once again, a soft sell, but if you're not, maybe it's a harder sell. If you're not giving up your time or because we've given a lot of time, maybe give up a little money to help us out here. So we'll talk more about it, but I think there's a donate button somewhere. You'll get solicited very shortly. Thanks, everyone.
Thank you. Ron.
Thank you. Have a good day.
Thank you.
All right. See you later.
Thanks.
Attention on evictions, stick to your convictions. Don't pay the rent. If at home we have to stay, then most of us can't pay, so don't pay the rent.
Mike, are we staying on? You're muted, Mike.